Hello, my name is Kate Johans, and it's my honor to serve as the Marketing and Communications Director for ATPE. I'm here today with ATPE Managing Attorney Paul Tapp, who's going to discuss the rights and options that Texas educators have if they do not feel safe returning to campus during the COVID-19 pandemic. Paul?
Welcome, everyone. So let's just get started, and let me start at the beginning and talk about what the topics we're going to cover in this webcast are. We're going to talk about a number of different things. First, options for alternative assignments and options for changes to expectations. We're going to cover those together because those are handled in the same way. So that's the best way of doing that. Then we're going to cover options for leave and finally cover options for resignation. We're taking in this order because we're starting with what normally would probably be the best option for a person if that option is available to them, which would be a change in the job, be able to work but with something that makes it safer. If for some reason that's not available, then we'll go into leave. If for some reason neither of those available, there are situations where resignation may be the best option. So we are going to talk a little bit about that as well. So
I was going to say, sounds good, Paul.
Okay, all right. So before we get started in this, I do want to talk just a moment about what we're not going to talk about, and that is what the actual safety rules are. We have a separate webcast where we go over the safety rules. If you have questions about what is required of your school district, that would be the place to go. But what we're going to talk about here is a situation where you may not feel comfortable going into the workplace, even though your district may be following those safety rules. What do you feel like if that is simply not enough because of your individual situation?
So it sounds like this is a situation where, I think that what we're hearing from our members is that they all very much want to work. They all very much want to get to campus. They all very much would prefer to be doing straight in-person instruction. We all want to go back to normal, but they need to be in a safe environment.
That is absolutely true, Kate. We hear that all the time. Just like you said, I want to work, I need to be paid, but I need to be in a safe environment. I don't think there is any teacher out there that was praying for pre-pandemic for remote learning to suddenly take over the teaching profession. Everybody likes being in the classroom, but it is totally reasonable to also want to feel like you are safe in going into the classroom and that your family members are safe in going into the classroom. So what is it that a school district is required to do in order to make you feel safe going into the classroom, particularly if you have some specific reason, some personal reason to feel that you are at higher risk because of a medical condition that may have you immunocompromised, or a medical condition of a family member that you're living with that may have them compromised, so that actually getting ill from COVID may be actually more dangerous to you than it would be even for the normal person. So let's jump right into that. So like I said, we're going to start with the possibility of changes to actual job. And what are we talking about? What we're talking about in that case is a word that most people have heard at this point, which is an accommodation. And what accommodation is it is a changes to the normal assignment that takes individual specific person's needs into account. Now, the most common thing we have seen over the weeks leading up to this school year for educators is, again, like I mentioned just a moment ago, a person who feels that they are at risk or a family member is at risk because of some underlying health condition that makes getting COVID-19 more dangerous for them than it might be for the general population. So let's get into what is it we're talking about when we talk about an accommodation. Well, what we are talking about is the Americans with Disabilities Act. Again, this is a fairly well-known law, one that most people have heard of at least, even if you don't know exactly how it works. This is what the Americans with Disability Act does. What it does is create a legal obligation for an employer to consider providing a qualified individual with a disability with reasonable accommodations. Now, I could basically say, well, I have just covered everything you need to know about the Americans with Disabilities Act. We can move on to leave now at this point, right? Well, as you probably are guessing, it's not quite that simple. You notice that there are some terms that I have bolded here. And in order to kind of explain to you about the Americans with Disabilities Act, I'm going to use these terms as a roadmap in going through what it is the ADA, Americans with Disabilities Act, commonly referred to as the ADA, actually provides.
So it sounds like disability may have a different definition than just the common thought that everyone would have.
Yes, Kate, that is very true. And that's a perfect example of what we'll be talking about here. So let's get into this. Now, you notice the first term I have is legal. And that's the most important thing as a preliminary matter about the ADA. We're not talking about your school district or a school district doing the right thing simply because it's the right thing and because they're good people. Again, we're talking about a legal obligation. So what we're going to be talking about is what is a school district legally obligated to do under this federal law, not just because, again, they're trying to do the right thing or they appreciate you as a teacher and want everybody to be safe. What is it that they have to do in this situation? So we're talking legal obligations, requirements here. So now that we know what we're talking about, let's get into it. Now, for the ADA to apply, the first thing is you have to be what's called a qualified individual. And what that means essentially is that you must be able to perform all of the essential job duties for your particular position. Now, I will say this can get to be a very detailed and very fact-specific analysis. Probably everyone listening to this has a job description that says what your job is, and to some degree or another, that job description may be accurate. But a perfect example is one thing that is commonly included on a job description is a requirement to lift 15 or 20 pounds or something like that. There are a lot of jobs that when it comes down to it, you can do the job even if you can't lift 15 to 20 pounds. The fact that something's on a job description does not mean it's essential. It is, again, very, very fact-based analysis here. You really do get into what is it you are being paid to do. For teaching, what that means is the basic essential job duty is being able to effectively teach students the curriculum, be able to impart that knowledge to students. Again, a little bit of an oversimplification, but it of course goes a little beyond that teaching, but that's a good example of the parameters. To be a qualified individual as a teacher, you must be able to teach. You may not actually have to be able to lift 20 pounds, but for the ADA to apply, first, you must be a qualified individual. Now, next, you must be a qualified individual with a disability. And here we're getting into Kate's territory. The ADA does have a very specific definition of the term disability. It does go beyond just our common sense idea. It's not totally different from our common sense idea, but it goes beyond our common sense just idea of what a disability is. And what the ADA defines as a disability is an impairment that substantially limits a major life activity. Now, again, you notice I have some bolded terms here, so we're going to unpack those really quickly. First, what is an impairment? An impairment is basically a medical condition, a medical or health condition. It's something physical, can be psychological as well, but it is a condition that you have that is affecting you in some way. Substantially limits. Now, this is a fairly common sense definition, and all of you teachers out there can get a good idea of what substantially limits mean. It means it can't be too minor. It has to, in some way, have some major effect. The thing that you have, the impairment, the condition that you have, must have some pretty major effect for, again, it to be considered a disability. There is no, I will tell you, there is no black and white line here as to when something is or is not a substantial limit. Again, it goes into the individual circumstances, how serious is it? But got a condition that substantially limits a major life activity. Now, this is an odd term, major life activity. What do we mean there? The ADA has a laundry list of things that can be considered major life activities, and it can be anywhere from walking, thinking, eating, talking. Obviously, all things that are major life activities. It also includes things like your immune system. Your immune system working properly to keep you from getting sick or normally getting sick is considered a major life activity under the ADA. So something that affects that, if you have a condition that impairs substantially your immune system, you may have a disability here, just the same as someone who's paraplegic and cannot walk, clearly is a disability, but so can an immune system be. It is a case-by-case determination. Again, we're talking a lot about specifics here. One thing we have probably all learned in the news is type 2 diabetes has an effect on the immune system. Well, the fact that you have type 2 diabetes doesn't necessarily mean you have a disability, because, again, your type 2 diabetes has to substantially limit your immune system, and that can vary. Medical documentation is necessary. Again, we're talking about health conditions here, and that means that we're going to need documentation from an individual that is qualified to make determinations regarding health conditions. That basically means a doctor. And so documentation is going to be necessary. Finally, I want to share, and this is going to be true through my whole talking about the ADA, but particularly here, this is a very complex area of law. What I'm telling you here is accurate, but it's accurate on a very general level. And we talk about the ADA deals with very individual circumstances, and I am leaving out a lot of nuance in terms of talking about the ADA. This is something we could spend all day covering, and we still wouldn't be able to cover everything about the ADA. So again, I want to give you a good understanding of kind of what it is that you're dealing with here, but this is a very complex area of law. So we now know legal obligation. We know that for it to apply, you must be a qualified individual. You must be able to do your job, and you must have a disability. You have to have something that's considered, you have to have an impairment that substantially limits a major life activity. So if that is the case, where does that get us? Well, you remember where we started with accommodations, changes in your job that might make it possible for you to be able to do your job. That's where the ADA gets us, is reasonable accommodations. So again, term we have heard of before. What does the ADA actually say about it? What the ADA requires is it requires an employer, including a school district, to engage in an interactive process to determine what changes to job duties would allow an otherwise qualified person to do the job. Now, those changes can be a myriad of things. The thing that has come up most often in the circumstances that we're dealing with here, again, we're talking about a very communicable disease. The thing that comes up most often, of course, is remote work. It would be safer for me to work from home than it would be to be back in the workplace. That's a very common request for an accommodation. That's not the only request for accommodation in this circumstance that could be made. Another request for an accommodation could be simply having it set up to where you can distance better. Having a room set up so that you can always be 6 feet from anyone that you come in contact with. Plexiglass is obviously something that comes up very regularly in terms of this communicable disease. Barriers that keep the airflow from going. Being able to go to meetings virtually rather than in person, again, is another possible accommodation. Accommodation is a very general term. It basically means all of these things that you could consider changing that would make the job more safe to do and make you able to come in a situation where, because of a disability, you may not be able to safely come in otherwise. But what the ADA requires is it requires the employer to, again, engage in this interactive process to determine what could possibly be available. Now, interactive process means just what it sounds like. It is a back and forth. It is not okay, you send us your information, we make a determination, we're going to tell you what that is, and we're done. It is a back and forth. And I mentioned medical information being necessary. It is very common that, again, making a request for an accommodation, send that request in, maybe with a doctor's note. Maybe that doctor's district feels like they need a little additional information that's not included in that doctor's note. They don't come back and say, sorry, you don't have enough information there, we're denying your request. What they're supposed to do is come back and say, we need more information from your doctor. Here is what we need from you. You contact your doctor, you get that, you share it with them. It is this back and forth until basically everyone has the information they need. Now, eventually it is going to get to a conclusion. We are going to be able to provide these accommodations, not these accommodations, but these, see if that is acceptable or not. And that is the next thing we need to talk about accommodations. And that is a district is only required to provide what would be considered a reasonable accommodation. And what that means is that they're not required to necessarily provide an accommodation to a person that they want, even if the person does have a disability that they want. That accommodation has to actually be available. Go back to the example that we had before about the remote teaching. Again, remote teaching may be a great accommodation for someone who has a serious compromised immune system. But for that to be a reasonable accommodation, there must be a remote teaching position available for the district to provide to the person requesting that. The district is generally not required to create positions as an accommodation. That's generally not considered reasonable. Another thing would be, of course, eliminating an essential job duty. Teachers do have to be able to teach. That would not be considered reasonable. But what it comes down to is that once an individual has shown that they're qualified, has shown that they have a disability, the district then is required to work with them to see if there is a possibility of having some reasonable accommodation so that they can actually do the job in a safe way.
So what would be an example of someone that might qualify?
That is a good question, Kate. So let's go through an example and kind of just use one generally to see how this would apply. So let's say we have a teacher who has type 2 diabetes, which compromises that teacher's immune system and makes a possible COVID-19 infection, more dangerous and more likely to lead to serious health consequences. So let's apply what we just learned to this very real scenario. So does the district have an obligation to accommodate? First, is the teacher a qualified individual? Now, I didn't share anything about this teacher's specific situation, but we'll just say that yes, that teacher is had type 2 diabetes for a while, is completely capable of teaching, just needs to do so in a safer environment with less chance of transmission of the virus. Does the teacher have a disability? Well, again, this is where that medical documentation is going to come up. The fact that they have type 2 diabetes does not necessarily mean that they have a disability, because again, we're going to need teacher's doctor to be able to share information that in their qualified opinion, that teacher's immune system is substantially impaired. So again, we need to get that medical information to show that there is a substantial limitation for it to actually reach disability. If in fact they're able to do that, and then we can show that this teacher does in fact have a disability, is there a reasonable accommodation available? Again, the teacher may want to have a remote position, teaching from home. There may be one available. If there is, districts certainly would need to consider that. If there isn't one available, the district would have to consider other options, though. Again, the ones that we talked about before of, some creating barriers or creating space so the teacher, again, could work in a healthier and safer environment than what otherwise might be the case.
So does the ADA apply to family members as well?
That is a very good question and something we need to cover here. And the answer to that question is no. The ADA only provides protections for the individual employee. Certainly understand that a teacher may have a spouse or a child that is immunocompromised and be concerned about going into work themselves and bringing the virus back home and infecting their family member. But the ADA does not apply in that case. It only applies in a situation where the individual employee has a disability. So the ADA is not going to help there, unfortunately.
So what if someone is in the situation where there is no reasonable accommodation available? What's the next option?
Well, that is where we get into our next issue. Like we talked about, and we're kind of going through a hierarchy of best options to worst. And if for some reason accommodation is not available, either because the individual has a concern, again, there's legitimate reason to worry about getting sick, even if you're completely healthy. But unfortunately, the ADA does not apply in that situation where you are just concerned, even if you're healthy, with getting sick. It also does not apply, again, like we spoke just a moment ago, if we're dealing with a family member that is immunocompromised, either has a health condition. So where the ADA does not apply and where a teacher just simply does not feel like they can go in to do the work that they are being required to do, it may be that a leave is their next best option. So that's where we're going to head next.
Okay.
So I'm going to focus mostly on paid leave options, because obviously those are the most beneficial. We're going to talk a little bit about unpaid, but we're going to start and spend most of our time on the paid leave options that teachers would have available to them. First, there are a couple that have existed for a long time and can help in this circumstance as well. First, anyone working for a public school district has state personal leave, which is 5 days per year of state personal leave that is available to them. It is accrued. If you don't use it 1 year, you have to have it to use the next year. If you change districts, it is supposed to transfer with you. So there are some people who have built up substantial banks of that, but again, you are supposed to get that 5 days per year, and it is supposed to be available to you at the beginning of the school year. In addition to the state personal leave, most districts provide some type of local leave as well, normally sick leave of some sort, but some type of local leave as well. Now, again, because this is not legally required and entirely up to the school district as to what they're going to provide, I can't give you much specific about it because it is up to the school district as to what it is they provide. It's very common. It's another 5 days, but some districts provide 3. And again, it's totally legal for a district not to provide any. Sometimes it is very similar to the state personal leave. Sometimes it is only for sick leave. In other words, you have to individually be ill yourself in order to use it. But there are these 2 types of paid leave that may be available if you need to be absent due to the pandemic.
Are there any types of leave that are specific to COVID?
There absolutely are, Kate, and that is where we're going to head next. There are a couple of types of leave that are specific to the pandemic. Now, the first is a little bit different than the kinds of situations that we've talked about so far, and that is emergency family medical leave. And what emergency family medical leave provides is paid leave if an employee is unable to work or work remotely. In other words, can't work either at the job site or remotely due to the needs to care for that employee's son or daughter who is under 18 because the child's school or daycare is closed or daycare provider is unavailable due to the pandemic. Now, notice that, again, this is a very specific type of leave. It only applies in a situation where school or daycare is closed. It does not apply to a situation where you as a parent simply do not feel like it's safe to send your child to school. This leave is not available in that kind of situation. But if it does apply, and there are certainly times and likely going to be more times when schools are closed, if this leave does apply, what are the specifics? What are the terms? First, for emergency family medical leave to apply, you must have been employed by your school district for at least 30 days. The first 10 days of leave are unpaid, although you may elect to use other paid leave if you have other paid leave to use. Again, we've got personal leave, we've got possibly local leave, and there's another type of leave that might be available to you, which we're going to get into in a second, another type of coronavirus specific type of leave we're going to get into a second. Now, if you are eligible for emergency family medical leave, if your child is not able to go to school or to daycare, what it provides is after that first 10 days of unpaid, it pays 2/3 of your regular rate of pay. For hourly employees, that's calculated by the number of hours that you normally would work. Now, there's a maximum amount if you are a highly paid employee. Maximum is $200 a day or $10,000 in total for the school year. That is the most, regardless of how much you can receive for this, even if you have a higher rate than that. That's the most that you can receive. Now, emergency family medical leave can last for up to 12 weeks if, in fact, a school or daycare is unavailable for that long. It is a type of family medical leave, which you probably heard of before. We're going to talk about that a little bit more in just a second as well. And that can go for up to 12 weeks. Now, if you've used family medical leave already in the school year, then the amount that you've used already will go towards that 12 weeks. So you may not have a full 12 weeks at this point. Again, this is a continuation of family medical leave. It is just an extension of family medical leave because family medical leave normally wouldn't apply to a situation where schools or daycares were closed. So that can apply, but again, in a fairly narrow circumstance. Now, there is another type of coronavirus specific leave as well, and that is emergency paid sick leave. Now, emergency paid sick leave is very much what it sounds like. It is much closer to sick leave. Now, it is available for a number of different reasons, 6 specifically, which I have listed here on the PowerPoint. I'm going to go through those briefly, and it's important to kind of keep track of these 6 because the benefits that apply are determined by why it is you're taking the leave, what the reason is for your taking the leave. So the first reason that you might take emergency paid sick leave is if you are subject to a federal, state, or local quarantine order. In other words, if you are told that you have to go home and quarantine. Now, one thing I will share at this point is, again, federal quarantine order, we know pretty much what that means. State quarantine order, we know pretty much what that means. Local quarantine order, we have a good idea. There is one big question that we have that has not really been clarified. And what that question is, it's very important. What that question is if you are ordered to quarantine by your local school district, does that count as a local quarantine order? We believe it should, but again, that has not been clarified in the law at this point. Whether, if you are told by your HR director or by your principal or by your superintendent that under the safety guidelines from TEA, you need to go home and quarantine, we think this should apply. But again, it is not actually clear in the federal law and the federal regulations that go along with it, whether that is the case. Second potential reason is that you have been advised to self-quarantine by your healthcare provider due to COVID-19. Now, that can be because you've gone to your doctor with symptoms and your doctor has said you've got symptoms and you need to quarantine. It could be because you have been around someone who either is symptomatic or has tested positive. And again, your doctor has said that you need to quarantine. But when there's a situation where you have been advised that you need to self-quarantine because of your health care provider, again, emergency paid sick leave may be available to you. Next, if you are experiencing COVID-19 symptoms and seeking a medical diagnosis, again, if you have the recognized symptoms of COVID-19 and you are going to get tested, but you have not gotten the test results back yet, again, that's number one situation where, generally speaking, you're required to quarantine. But even if for some reason you're not, again, emergency paid sick leave would apply in that situation. So those are the first three reasons. You notice those are all related to your situation, your own potential illness, your own potential quarantine. The next two, which are the next two important ones, are related to you with someone else who has a condition. So the fourth possible reason is you are caring for an individual who is subject to either number one or number two above, either that you're caring for someone who is subject to a local quarantine order, or you're caring for someone who has been told by their healthcare provider that they need to quarantine. In that case, again, emergency paid sick leave is available to you. Finally, if you are caring for your son or daughter because their school or daycare is closed or unavailable due to COVID, again, you can use emergency paid sick leave. Remember when we were talking about emergency family medical leave, and I mentioned that the first 10 days were unpaid, and you could possibly use some other type of paid sick leave to cover that first 10 days. This is one of the types. Again, I mentioned you might be able to use state personal leave. You might be able to use local leave. You can use emergency paid sick leave to cover that first 10 days if necessary. Finally, we have a situation. The sixth and final reason is you are experiencing some other condition that has been specified by the Secretary of Health and Human Services. Now, at this point, we don't have any. Again, the law provides that could be the case. That hasn't happened yet. Could sometime through, in the future for the rest of this year. But at this point, that has not happened. But these are the 6 reasons that you can potentially use emergency paid sick leave. Now, you remember I said that it was important what the reason was, because that had an effect on what the benefits are under emergency paid sick leave. So let's get into a little bit more of the terms and specifics of EPSL. First, before we get into the compensation, we'll get into how much EPSL you get. For full-time employees, you are entitled to up to 80 hours. It's understood that you normally work 40 hours a week, so you get up to 80 hours of EPSL. For part-time employees, it's a little bit more complicated. Basically, it is the number of hours that you would, on average, work over a 2-week period of time. So if the number of hours varies from week to week, there's an average taken. If it's the same number every week, obviously it's that number over the 2 weeks. But if it varies, it is the average number over those 2 weeks. So it's basically 2 weeks worth of leave, whether you are full-time or part-time, just 2 weeks of what you normally would be working. Rate of pay. Remember what I was talking to you before about reason for leave. If you are taking EPSL for one of those first 3 reasons, remember it is something related to you. Either you are being told to quarantine by federal, state, or local order, your doctor has told you to quarantine, or you're experiencing symptoms and getting a test, you receive your normal full rate of pay. If it is one of the other reasons, you're caring for someone who is under quarantine or has been told to quarantine, or again, that last reason that really hasn't come into being yet, you only receive 2/3 of your normal rate of pay. You don't receive your full normal paycheck, only 2/3 of your normal rate of pay. So again, the reason you're taking the leave is important. Again, like the emergency family medical leave, there are maximums for compensation for emergency paid sick leave as well. The maximum is $511 a day, $5,110 aggregate, again, for use for one of those first three reasons, $200 a day, and a $2,000 aggregate for use under those later reasons, caring for someone else. So again, it depends very much on the reason for your leave as to what the benefit really is. Now, one final thing I need to share with you regarding both of these coronavirus specific types of leave, emergency family medical leave and emergency paid sick leave. Again, these types of leave are coronavirus specific. They were enacted by Congress last spring under the Family First Coronavirus Response Act. Under the terms of that act, both types of leave expire December 31st of 2020. In other words, unless Congress does something to extend the availability of this leave, both of these types of leave will disappear at the end of this year. So if you have no reason to use it, it may be a best bet to actually use one of these types of leave and save your personal leave or local sick leave, because again, we don't know whether these will still exist for the spring. And we do know that it is very possible that the coronavirus, the pandemic, may still be existing for the spring.
So you've mentioned these as paid leave options. Are there also unpaid leave options?
There are also unpaid leave options, obviously for not as good as the paid leave options, but they may be things that need to be considered. And there are two that we want to cover quickly here. The first is family medical leave. And again, this is again, most people have heard of family medical leave. This is the leave that's existed for a few decades now. And what family medical leave does is it provides up to 12 weeks of unpaid leave for a person with a serious health condition, as long as that person qualifies for the leave. Now, Family Medical Leave Act has very, very long, very specific definitions of what a serious health condition are, and they're much too long for us to go into this afternoon. I can say that you do have to have a health condition. Again, just a concern about getting sick, a concern for safety is not a serious health condition. You have to have some underlying health condition that would meet the definition. But for a person who does, and again, someone who's immunocompromised may, I cannot say you do, but someone who's immunocompromised may have something that would be considered serious health condition. Again, this may provide a longer term leave benefit than you may have available under your paid leave options. Now, again, for the family medical leave to apply, you have to qualify for it. And the qualifications here are a little bit more stringent than the qualifications for the emergency family medical leave. To have family medical leave, normal family medical leave apply, you have to have worked for at least 12 months for your current employer, your current school district, and you have to have worked for at least 1,250 hours over the previous 12 months. Now, I will say for instructional personnel, there is a particular regulation that acknowledges that teachers particularly spend a lot of time working off the clock, grading, preparing. And so it is the district that has to prove you didn't work the 1,250 hours, as opposed to you having to prove that you did work the 1,250 hours if that number of hours gets to be a question for you. But family medical leave does provide longer leave options if you do need longer leave options. They're unpaid, but they do at least protect your job if you do have a serious health condition. Now, a second unpaid leave option is temporary disability leave. And this is available to any full-time employee who is required to be certified by the State Board for Educator Certification. So certified administrators, teachers, and classroom aides are generally required to be certified, would generally have temporary disability leave available to them. Unfortunately, office staff, cafeteria staff, bus drivers would not have temporary disability leave available. What temporary disability leave does is it provides up to 180 days of, so basically about half a year, about 6 months, of unpaid leave if you're experiencing a disability that interferes with the performance of your regular duties. Now, I'll have to say that the temporary disability leave does not have the very detailed definition of the term disability that ADA, Americans Disabilities Act, does. In this case, it is much more of our normal kind of understanding of what a disability is. I would say that even though temporary disability leave has been around for a long time, there has not been a lot of litigation or other consideration of what is or is not a disability. Since it doesn't provide a whole lot of benefits, honestly, people haven't argued about it a whole lot. So we don't really know whether there would be any argument of, oh yes, your immune system is compromised, but we don't think that's a disability under TDL. We just haven't had that situation because, again, it just has not come up at this point. But those are the main two unpaid leave options. So between the two, between family medical leave and temporary disability leave, again, they can provide you with more extensive leave options that last longer than your paid leave. So it may be that those can come in and handy, be beneficial to you.
So if those, basically what happens if, I've used all my leave, the district's saying I can't get an accommodation, do I have any options left?
Well, Kate, unfortunately, you do, but the option is not the greatest. It is one that educators, honestly, we know are considering this year more than ever before, and that is just leaving rather than going into an unsafe environment and putting their health at risk or their family members' health at risk. It is resigning from their position with the district. Not a great option, but it is one that, again, if the better options, a possible accommodation, possible leave are not available or have been exhausted, then this may be the only option that is still available. So let's get into basically the specifics of resignations, because that is not quite as simple as it may seem. The most important thing, the most important consideration regarding resignations is whether or not you have an employment contract or not. If you do not have an employment contract, you are considered at will. That's the term that's used in Texas. And it's basically synonymous with not having a contract. The person who's working at will is a person who simply does not have an employment contract. And if you don't have an employment contract, you can resign your position at any time for any reason without any penalty. I mean, obviously there's a penalty if you don't have a job anymore, but there is no other penalty that applies to that. It is common, of course, to give 2 weeks notice. That is not required by any law. It is just a professional courtesy to do that. But if you do not have a contract, you can resign for any reason that you want. And there is nothing the school district can really do about it. But if you are a certified educator, you are likely employed under a contract. And under that contract, you must do one of two things in order to leave the district without risk, generally speaking. You must either submit a resignation at least 45 calendar days before the first instructional day of the school year. Notice I said calendar days, not school days. Or if you do not submit resignation 45 days before the first instructional day of the school year, and again, notice that I say instructional days, not your day, first day to report is the day the students report for instruction. If you do not submit the resignation by that deadline, you must be released from your contract by the school district. If you are not released by from your contract by the school district, it is possible that you could suffer sanctions for leaving anyway. A school district can file a complaint with the State Board for Educator Certification, we regularly refer to as SBEC, for what is called abandonment of contract. And what that means is simply what the situation we just described, that you have left, have not submitted a resignation before the deadline, and the school district has not agreed to let you go. If they agree to let you go, there's no problem. But in this case, they have not agreed to let you go. In that case, a school district can file a complaint with the State Board for Educator Certification. SBEC then can sanction an educator after due process, after they investigate the circumstances, after they provide a hearing, if they found that the educator has abandoned a contract, has left without providing a deadline before, or excuse me, a resignation before the deadline, or been released. Now, the sanction that SBEC can apply, and their only authority is over certification, your license. The sanction that they can apply is a 1-year suspension of the certificate, which again means that can't teach for a year, and that a notice of that suspension is placed on your virtual certificate forever. It will always be there even after the suspension is lifted, even after the certificate is revalidated. There will be a notice of that suspension on the certificate for the rest of your career. So that is the possible risk of leaving without either, again, a resignation before the deadline or being released by the school district. But you notice that I said there is a circumstance where you may not be actually sanctioned by the State Board for Educator Certification. And that circumstance is if you have something that is considered good cause to leave the district anyway. If you have good cause, then the State Board for Educator Certification will not sanction you, even if the school district does submit this complaint. So what is good cause? There are 2 reasons in SBEC rules that can apply in this situation that can show that an educator did have good cause to leave and therefore would not be sanctioned. The first is a serious illness or health condition of the educator or close family member of an educator. Notice we're talking serious illness or health condition. We're not talking about concern. We're not talking about possibilities of getting sick here. But if you have an underlying condition that can, and again, we're going to likely need medical certification of the seriousness of it, but can cause a health concern here that may be considered good cause for you to abandon your contract, for you to leave without having submitted a timely resignation and without the district agreeing to let you go. Again, though, it does have to be a serious illness or health condition of either you or close family member for this reason to apply. The second possible reason is a significant change in your family needs that require you as an educator to relocate or to devote more time than allowed by current employment. Now, this could be a situation, again, it's possible that health concern could fall under this category. Another situation that could fall under this category is if you have a child and you have determined that you do not feel comfortable having your child return to school. So your child isn't home and you don't feel like your child is old enough or mature enough to be home alone. It is possible that this could be a situation where SBEC would consider that you have good cause. Now, I have to share in both of these, this is the first pandemic we have dealt with the State Board for Educator Certification, and the first pandemic that SBEC has really dealt with. We don't have a track record for them. We don't know how lenient or how strict they're going to be about these situations. But it is very possible that if you have a documentable concern, again, particularly health issue with you, family member, or some real need for your family, particularly students who are not able to go to school, even if it's your decision that they don't go to school, it is possible that you would be able to leave without being sanctioned for that. So again, for resignations, the most important consideration is whether you have a contract or not. If you don't have a contract, you can leave for any reason that you want to. If you do have a contract, it gets substantially more complicated, but it is very possible that the rules as they exist now could give you, number one, circumstance where the school district would agree to let you go. And even if they don't agree to let you go, that you would not be sanctioned for leaving.
Well, thank you, Paul. This is all really valuable information, and I'm sure our members will find it very useful. I do want to remind everyone that if you have additional questions and are seeking other general information about your rights during the pandemic, you can continue to visit our COVID-19 resources page, which is available at atpe.org/coronavirus. Once again, Paul, thank you so much. And thank you to everyone who has watched this webcast. We greatly appreciate all that you do for Texas students.
And I want to say thank you myself, just for, like Kate said, you always go above and beyond. And this year you are going above and beyond your normal going above and beyond. So thank you for all you do.
Thank you. Have a great day.